Thank you. We're going to be having only hearings today. We're not going to be doing any executive sessions. So let's start off. Representative Yokella, would you like to introduce the bill? Okay. Before you do that, I'm going to ask the clerk to take attendance.
Thank you, Mr. Chairman. Chairman Dolan,
Here.
Vice Chairman Piemonte. Here. Clerk is here. Representative Tripp. Representative.
Present.
Okay. Representative Guthrie. Representative Lasalle.
Here.
Representative McBride. Representative Melvin. Here. Representative Ayer. Representative Power.
Here.
Representative Trelevin. Representative Gilman.
Here.
Representative Majori. Here. Representative Stavis. Here. Representative Mangaputi. Here. Representative Van.
She's going to be, she's at OLS.
Okay, thank you. Representative Klee.
Here.
Representative Gallagher.
Here.
And Representative Rung.
Here.
Thank you.
Thank you. Representative Yokella, floor is yours.
Thank you, Mr. Chairman, and thank you, members of the committee. For the record, my name is Representative Josh Yokella. I represent Rockingham 33, Fremont, Danville, and Brentwood. And today I'm introducing HB 1136, just requiring planning boards to list the type of studies that would be required to render a decision. There are requirements to, post the fee schedule for planning and zoning fees that would be applicable to applications, in the hopes of allowing people to be able to predict what the cost of their application is going to be so that they can plan accordingly. And I see that this is just one piece of that, so that they can be able to predict better what their expenses for their application is going to be, the range of possibilities as far as that expenses, depending on which studies that are listed would be required for them, and also allow that they wouldn't be required to repeat the exact same study multiple times, because that would obviously increase the cost of it, a cost of the application. Obviously, if a change was made to the thing that was studied, then obviously that wouldn't be an issue if it needed to be restudied. If you study the water drainage issue and then you make a change to the drainage, it makes sense that the board would be able to require a new study with that new information, but not if you didn't make a change to the drainage and they would just want to try and get a different answer from that study. That's kind of the goal of this bill, and I'm happy to answer any questions.
Thank you. Before we get started with that, just for the record, we've had two people register for this bill, one for and one against. So does the committee have questions for the representative? Yes, Representative Gallagher.
Hi. I'm wondering if you could provide us with a bit more specificity about how repetitive is defined here, like how are interpreters of this law supposed to decide whether a study is repetitive or not?
Thank you for that question. So in the bill it says, so repetitive studies, so it wouldn't be, you would be studying the same thing again. It would not be allowed unless there was a change to the plan after the study's completion, which substantially impact the issue studied. So if you study drainage and then you change the drainage of the plan, then the board would be able to ask you to restudy that drainage impact on the plan. But if, let's say you study the soil samples for wetlands impact, or maybe a better example is traffic study. If you did a traffic study on your plan, because you're building a development of 10 houses or something, and you want to be able to find out what's the impact on the road's going to be, and then you change the drainage, you shouldn't really have to restudy the traffic study again, because changing drainage doesn't really affect the change of the traffic, right? So that was kind of the wording and how I think it would be handled in practice. And then I think that the board would take a vote on whether they believe that the change substantially impacted the issue studied, and obviously any ruling of the board would be able to be appealed to the ZBA, and the ZBA would be the place if there was a disagreement between the applicant and the board, so that could be resolved. Thank you for the question.
Representative Davis?
Good morning, Representative, and thank you for taking my question. I have a number of questions about this bill. As a member of a planning board for a relatively large municipality, first, can you tell me where the title of the bill, dilatory studies, comes from? Because it's nowhere in the statute.
So I didn't write the title of the section, so let me just, I would have to look that up for you.
Well, but more importantly, my question speaks to the meaning of the word dilatory in this context has a negative connotation, when in fact many planning boards in the course of reviewing projects must do multiple tests on the same issue, and part of their due diligence process. Yeah, I also have a question about your mention in your introduction of the bill about listing fees for applicants, and I don't see that anywhere in your bill.
No, that's currently required. It wouldn't be changed.
That's correct, but
Right.
you mentioned it in your introduction of the bill, which made me think that there would be additional language concerning fees.
Thank you for the question. So the cost of, my point in mentioning it in my introduction was that the cost of the studies are part of the cost of that application. And so currently there are requirements to post the fees for the application, right? And so in a sense, all this is doing is saying, we understand that we're supposed to post the fees for the application, and some part of that cost could be studies, and therefore we're going to also let you know that these studies may occur. Obviously, the size and the scope of the study will affect the cost, but being aware that that these are part of that process, or they could be part of that process, would help them understand whether or not the total scope and cost of the project as far as the application. Thank
Follow-up,
you.
Mr. Chair? Follow-up, Mr. Chair?
Yes, please, go ahead.
Thank you, Mr. Chair. You also said in response to the previous question that if a planning board, if this bill were to come law, wanted to do another study on the same issue, that there would have to be a vote taken by the board. But I don't see that in your bill.
So, thank you for the question. So if you wanted to do a traffic study, and then the board wanted to do another traffic study, they would have to decide whether or not they are allowed to do that, right? Under this law. And
But this
that
prohibits
discussion,
them from doing it.
about whether or not they're allowed to do it would be up to the board. They would vote on whether they believed it would substantial, if the study, if they're allowed to do it because the plan substantially changed the impact of the issue that was studied. So if you come to the board, you study the traffic study, and then you add 10 more houses, and then the board would say, hey, maybe we want to study this traffic study again because there's more houses, the plan has changed, there's going to be more traffic, and so we want to know what that impact is, right? The board would say, okay, we, according to this law, we read it to substantially impact that issue, and they would make a ruling about whether they believe that was impacted. Whereas maybe adding one house, the board would say, it's, the one more car would not be substantially different than the information that we got from the first traffic study.
Thank you.
Question
Exactly.
from Representative Rung.
Thank you, Mr. Chairman, and thank you, Representative, for taking my question.
Absolutely.
I'm trying to understand if this is a solution looking for a problem. Can you cite any specific situations that brought you to draft this bill?
So thank you for the question. I would, obviously, I only live in one town, so it would only be relevant to my experience in my own town. It wouldn't be, a larger study of how much this impacts people in other towns. It would be anecdotal, anything that I said, but there was something in the town that I live in that was controversial in the town, and some of the people on the board were not satisfied or did not like the person that was chosen to do the study. They did not like the answer of the study is kind of what came about it. And they wanted to look into that issue again to try and get what they thought was the correct answer. And so it's just trying to make, in that example, the people were trying, I think, to kill the project by just studying it to death. But I think in general, it's important to be upfront with what the fees are of the process, and that's why we have it required now. And so I'm just trying to expand on that.
Representative Power.
Thank you.
Thank you, Mr. Chair, and thank you for taking my question.
Absolutely.
So in preparation for this bill hearing, I did two things. I referenced RSA 674, and that lists provisions, A through E, to which you would like to add F as outlined or within the framework of this bill. And secondly, I looked up for my town the site plan regulations, and I noticed on page 7 my particular town in fact does list studies. For example, environmental impact, hydrological impact, groundwater quality impact, traffic impact. parking studies, and then they also list and other special studies. And then it goes on to say, or any other study deemed necessary by the planning board in order to make an informed decision. So my question is I'd like to better understand the purpose and the intent of this bill, because you say list studies. So to be very specific, what is this bill asking to do? Are they directing municipalities to list within their ordinances very clearly, because I only spot checked Brookline. I do not know if
Right.
other municipalities are in fact taking the step to list studies. And furthermore, I do understand that, again, looking at my municipality,
Yeah.
that they did list fees. So is the goal and the intent of this legislation, is it to clearly list any such studies and also to publish within the municipal's ordinances fees associated with those? Could you clarify? Thank you.
Thank you for the question, absolutely. So it's good that your town is listing some of the things that they would be studying. However, obviously, the list is not comprehensive, and that, I believe, is a problem as far as, transparency and what the costs of that application might be. And there is, so the cost of each study is going to vary widely depending on how much there is to study. So you wouldn't be able to say like, oh, we're gonna charge you a certain flat fee for this study. You would have to go and acquire the study, and depending on how much work is in that, how much of the impact it is, or how long the study needs to be, that's going to affect, obviously, the cost of that study. So I don't think that it's even possible to list the amounts of what the studies would cost. It's just a guideline to say, okay, we're going to study the parking and the traffic and maybe the water table. These are the things that this town is looking at when we set up an ordinance. We set up what is allowed to be in each district, let's say. And so if you have industrial things going in, then you want to be able to make sure that the water table is going to be safe and those types of things. So those things that you're looking at should really be listed, and not anything else that we imagine or looked up on the internet last week, kind of a thing. And we're going to add that to the person's requirement for getting this passed. Thank you for the
Follow-up,
question.
Mr. Chair?
Yes.
Thank you, and thank you for taking my follow-up question. So relative to the language in this legislation, proposed Section F, could you also tell me if the term substantially impact is defined anywhere? I'm interested in knowing the criteria for that, because it says after a study completion which would substantially impact the issue. Is that defined anywhere else in statute that we could reference? And could you expound on that definition?
Thank you for the question. As I was saying before, I'm not aware of anywhere that substantially impact is defined, and it's not defined in this this ordinance. If you believe that that is necessary, and that the board would not be able to decide that on their own, whether it had a substantial impact or not, with the, as already explained, with the caveat that if there was a disagreement, whether with obviously abutters or the applicant, and whether it was substantially, any decision made by the board can be appealed to the ZBA by the abutters or the applicant. And so if there was a disagreement on that issue, that would be able to be appealed and discussed more thoroughly with, the appropriate, through the appropriate process.
Representative
Thank you.
Clee, have a question? Can you turn off your mic, please? Anybody else have any questions for the representative? Yes, Representative Davis.
Yeah, thank you, Mr. Chair, and thank you for taking yet another question, Representative. So, under letter F in your bill, there are several grammatical errors that I would just like to point out. One is that you list studies in line 4 as a plural noun.
Representative, could you
Yes,
turn it
and
into
do you,
a question?
thank you, Mr. Chair. Do you mean that to be a possessive, singular noun? It confuses me.
Thank you for the question. Let me just reread. Let's see. Studies listed. Yes, you're right. It should be possessive.
Thank you.
Thank you.
And then, and my last question is about the phrase "which would substantially impact the issues studied." Does that refer to the studies or to the development being reviewed? It's not clear from the wording of the bill.
Thank you for the question. I'm not sure of a way in which a study would impact the issues studied. So I think that the only way to understand that language is that it has to be the plan. Is the thing that changed. So thank you.
Any further questions for the representative? Representative Yokela, a question was brought up about language. Would you expect that you would bring forth an amendment to correct that, or are you okay the way it is?
With the possessive,
Right.
I'm happy to draft an amendment. I would be more interested if the committee was wanted me to draft an amendment to define substantially. That would be more of. I'm happy to do the possessive. Obviously, that's just a grammatical change, but I'm happy. I'm willing to work on whatever the committee believes is appropriate. So I'm happy to propose that amendment for the studies correction, the grammatical correction, and if it is the will of the committee, anyone could reach out to me and say, via email or say right now that that's what they would like to see as an amendment, and I would be happy to do so as far as defining substantially.
Any further questions from the committee? Yes, Representative Gallagher.
If you're going to be doing an amendment, I'd appreciate it if you could include your testimony about the definition of repetitive as meaning referring to the same subject matter in your amendment too.
That would be okay. Thanks for that.
Any further questions? Any questions from the public? We did have a request to speak from the NHMA on this.
Thank you, Mr. Chair. Nate Grace for the New Hampshire Municipal Association. We object to this bill as written, and based on what I've heard here today, we would also object to the amendment. The first thing I want to point out is that this would amend RSA 674:44 Roman 3 by inserting a new subparagraph. That statute is the statute that requires a planning board to adopt site plan review regulations and lists what is required in those site plan review regulations. So essentially, what this would do is just require exactly what Brookline does. Although, of course, if there's already a fee attached to it, they would already have to list what they want. So It doesn't really change anything. And the problem is you would end up with a list exactly like Brookline's, because the planning board wouldn't necessarily know all possible studies. And it might be the case, for example, that in a place that's heavily impacted by PFAS, if DES enacts a soil surface standard, that a project that would result in substantial digging or something that would disturb the soil might require some sort of study related to that. I don't know what that is. I don't know if anybody knows what that is at this point in time, but a simple listing of all possible studies doesn't really help applicants know what they need, because certainly if you're proposing a big box store, you can assume a traffic study makes sense, but if you're building a house, that doesn't really make sense. If you're building, on top of a mountain, you're not going to need a wetland study, but you are if you are in a place where there's going to be a possible wetland. So it doesn't really help applicants narrow down what their costs are going to be. Already they have the option of going to the planning board prior to submitting an application, speaking with the board on a semi-formal basis, saying here's kind of our plan, what do we need to know, and there is an obligation of the planning board to talk to them and to say, based on where you are in town, we've seen that there are wetlands from other applications, you might need a wetland study, that's something you might want to look into, and the list goes on from there. And that's really the best way for the applicant to know what the costs would be before they go too far into the project. And they can certainly do that at a preliminary design phase, where they would go in long before hiring architects or anything and saying, I own 20 acres, I want to subdivide that into 20 lots and build a residential place. What do I need to know? And the town is obligated to tell them what they need to know about that. The other portion of the bill as proposed would prevent duplicate studies. Already we have in place RSA 674:4-B, and that's for the planning board, and RSA 676:5 Roman 5A, which is for the ZBA, which essentially says, on the one side, the planning board can't require substantially duplicative studies, or the same studies as the zoning board, and vice versa, because if you have that information once, you can't require applicants to go out and get it again. It sounds from the discussion like there might be cases out there where an applicant goes out, gets a study, and then the abutters who live next to them don't like the result, or they don't like what the applicant's doing, so they get their own study. Both sides have the option of presenting that to whichever board they're in front of, and that board has an obligation to determine which one is best. And it may be the case the board needs to hire an expert to help them sort through the studies if it's a highly technical analysis, and point out, what the errors are, or what the different factors are, and then it's ultimately the board's decision as to what study is more persuasive, which one to believe, much like a courtroom. So that's really what I wanted to point out to the committee. I'm happy to take questions.
Anybody have a questions for the NHMA, Mr. Gray? Yes, Representative Mangiapudi.
Thank you, Mr. Chair. Thank you for taking my question. From your testimony, what I'm understanding, is that true that this bill does not clarify or help preventing repetitive studies in all scenarios? So when you change an RSA, it's not just one particular small town, but it also impacts every municipality or city or every community. And how would this impact the larger communities, for example, like in Nashua? What would the zoning board have to face if this, would it make it more restrictive?
Well, thank you for the question. So I really don't see how this would enhance an applicant's ability to do anything, because they might, for example, go in and say, I want to subdivide my property and build however many houses. They start doing a study and, they realize, hey, there are wetlands here. maybe instead of going through the whole process of getting the excavation permit through DES and all of that, we're just going to change the plan. And then you have to make sure that whatever information you've given to the board corresponds with what your plan is, right? Otherwise, why do it? So if their initial study didn't capture enough information to inform the board about their new plan, then you have to redo part of the study. And so I don't think that this would assist them in any material way.
Just a quick follow,
Yes,
Mr.
go
Chair.
ahead.
Yeah. So basically, it's not helping the person who's applying to reduce the fee or do the repetitive, but it gives the municipalities and the towns the platform where, as it stands now, it gives opportunity for all parties to work it through if there is any issues, right?
Right, and under the existing statutes, you know, you might have someone go in with their application, go before the planning board requires that wetland study, and part of the planning board approval process is that they, you know, they can't approve the plan without a variance, so the applicant goes to the ZBA, and halfway through that process, they realize, you know, maybe it's more economical, maybe it's a better idea, whatever the case is, they decide to change the plan. And if your initial study already captured that, the ZBA can't go back and say, well, you need to do the study again. That's already prevented under the law. And once they're sent back to the planning board can't say you have to go back and do the study again because it's already, they already have the information. It's not allowed.
Any other questions for the NHMA? Seeing none, thank you very much.
Thank you.
And that concludes our hearing on HB 1136. Our next bill to be heard is 1161, which is relative to ethics obligations of elected local and county officials. Thank you. Do we have anyone that wishes to introduce this bill, 1161? Yes, please. Please, go ahead. No, push the button. B.
Okay, we're good. So, thank you for hearing me. I am Representative Callum from Sullivan District 6. And just for a little bit of background, I've been at this. And so my experiences are the main reason for bringing this. And I had input from others in the county. So I think that this is a case of the timing is past due. You all have the paper in front of you. I don't know that I really need to read it. Suffice to say that the intention is to try to bring the same level of ethics to county and local government that we ourselves as representatives have to assign to. And in the past, there's not been anything unless it's written entirely by a local government, which they would still have to write it, but at least you would have a state statute promoting that they do that. This bill is also co-sponsored, pardon me, by Representative Stephen Smith of Sullivan 11, Representative Stapleton of Sullivan 5, and Representative Baxter of Rockingham 20. I don't believe any of those are here today. So my intention was to introduce it and take any questions.
Thank you. Representative Power.
Thank you, Mr. Chair, and thank you for taking my question, Representative. So my question focuses on line 21 of the bill language, specifically the term removal by the voters. So I would like to understand by what mechanism shall the person be removed by the voters? Would it be by a recall election, and who would initiate that? Would it be the governing body, or would it be by a petitioned warrant article, potentially a regular meeting, which is probably unlikely, and most likely it would be by a special meeting? Could you please explain the mechanism by which this person would be removed by the voters? Thank you.
So that particular line, as it appears, was put in by the writers from downstairs. And I'm not sure that I had a grasp on legalities to make that more specific. And I struggle with that myself. Because I'm not a legal individual, I don't know what is the correct mechanism to make something happen, but my guess would be that you would end up with a special election or something of that sort. Or if they mean by the people, that, for example, the selectmen would have to pursue legal avenues, which may be the real possibility. I don't have a straight answer for that.
Follow up, Mr. Chair?
Yes, go ahead.
Could you please edify me with regard to special elections? I meant recall elections in New Hampshire. Is that in our statute?
So I asked that question of town council, and the answer I got was that New Hampshire does not have a provision. Now, I did not look myself yet to see if this is true, but what I got in writing was that New Hampshire does not have a provision for recall elections, as some states do. So I'm confused about the mechanism myself.
Okay, any other, yes, Representative, go ahead.
Thank you, Mr. Chair, and thank you, Representative, for taking my question. Like you, I've been a member of my select board for many years, and in my first term, or maybe my second term, myself and our two other select people wrote an ethics policy for the town, a comprehensive one. Between the three of us, we have 2 PhDs, a master's, and 2 Ivy League degrees. When that ethics violation or that ethics policy was tested many years later, it hadn't been tested for a while, it was proven to be garbage. And it was proven to be garbage, and here's my question, because you have a right to your First Amendment, to speak your mind, to say what you will say. My question to you is then, how do you reconcile your First Amendment rights against Section 30 in here, which is your right, you have to adhere to ethics?
That's a conflict. I can't deny it. My issue was to try to get something started that would take us to some point that people who run for office would understand, as we as representatives do, that there are certain things you've got to disclose, even if you're a businessman, a contractor. You got 10 implements and 3 guys working for you, and you bid on a job. Well, if you're sitting on the board yourself, at least everybody in town ought to know that you're bidding on something that you're sitting on. That is my main focus. And like I said, I don't have all those PhDs. I'm just a Joe Blow who was in the Navy for a while, and I have all the best intentions, but I don't claim to be legal and know how to do it.
Representative Van?
Thank you, Chairman, and thank you for taking my question. I wonder if you have thought about how this proposed bill would affect membership on boards. The planning board comes to mind particularly, where often people serve on the board because they know about something. It seems to me as though this is going to create a disincentive for someone to serve on their planning board because, oh, they developed a house once, therefore they have a conflict. Could you talk about that a little bit, please?
So if it were myself, and I were gonna sit on the board, and I believe I had a conflict, and in a couple of cases, I have mentioned those conflicts. And what I have done is said, I have a conflict with this interest, or this situation, and so I will be abstaining. Would you like me to leave the room? I don't think that that is anything to expect a person to do. The problem is, at this point, it's really voluntary. And there's a whole lot of people who don't necessarily step up and volunteer that information.
Yes, follow up, go ahead.
My question was really more of a general one. The way I read the bill, it sounds as though shall have any interest, financial or otherwise, direct or incorrect, in any business or transaction or incur any obligation of any nature that is in substantial conflict with the proper discharge of his or her duties as prescribed in the laws of this state. That seems fairly general, such that someone who works in the field might not be able to serve at all. I understand your example of, oh, well, I live next door, therefore I have a conflict, or I bid on this job, therefore I have a conflict. But the first clause here feels more general. Was that your intention?
And you're saying starting right at line 5?
Yeah, starting at line 5.
Give me a moment, please.
Sure.
Yeah, it's very general. I think the problem here is that I don't think you can possibly write anything that's specific to everything. That's why it has to be general. Lawyers need to work on this and fix it better than I've got it, but I don't know how you would write something that fits every single situation.
Yes, Representative Davis.
Thank you, Mr. Chair, and thank you, Representative, for taking my question. I have two questions. One has to do with lines 21 and 22 of the bill, where it says that anyone who is found to be in conflict with this ethics policy shall be guilty of a misdemeanor. Is it a Class A or a Class B misdemeanor?
I don't actually know that.
Penalties are substantially different for each one,
I
and there is due process that must be followed that has nothing to do with removal by voters. So how would this bill move someone from an elected or appointed position that is judged to be in conflict with the guidelines of this bill that outlines ethics through the criminal justice system to be indicted of a Class A or a Class B misdemeanor? How would that actually happen? Who would bring the charge? Who would hear the charge? How would it happen?
That's something I would have to research and get back to you. I don't have an answer for that, no.
Thank you.
Representative Majapudi.
Thank you, Mr. Chair. Thank you, Representative, for taking my question. Many of the boards are either voluntary or it pays a small token of stipend. And if somebody is working full-time and their expertise is in that field that we want their input on a board, for example, public health board, we want a doctor who is a public health official, not in that town or, elsewhere, but need to sit on it. I mean, many of the boards in New Hampshire is voluntary. So would your bill, would it preclude participation because of this high penalty and high stakes, which is very vague?
I think in looking at some of this wording, you might believe that to be true. As I said before, my intention was more to get people to, shall we say, own up and be clear and recuse themselves, not necessarily to stop them from bidding on a job, but to have them be clear so everybody else knows what's going on, that it doesn't, as it sometimes happens, that no one in town is clear about who's actually sitting where and doing the job.
Representative Klee?
Thank you, Mr. Chairman, and thank you for taking my questions. It does reference in governing bodies, and the definition of governing bodies sounds more like it's an elected position for selectmen, so on and so forth. But where I do agree that there could be conflict, I also sit on a board of aldermen. And anytime someone has a conflict, for instance, a spouse is in the schools, works in the schools, and there's a contract coming up, they always recuse themselves. If there's they work for a nonprofit and there's some kind of grants that are going up, they'll recuse themselves from doing that and so on. So I see it happening within my town. And I think my concern with this is that if we start forcing people to disclose any potentials or possibilities, and it goes beyond the governing body of the elected officials, as I believe that Representative Manjapudi brought up. So my question to you is, do you feel that this could go beyond the governing body, the elected officials? Do you think that just the voluntary, I know, pardon me here, so I know that you put this through because you felt people aren't stepping up to the fact, but is there a specific case, I guess is a question that I'm asking, that brought this to your attention or any of the other authors?
Okay, so in the past, in the town of Unity, a selectman or two, couple of different cases, in actual different situations, not the same time, one of the individuals is deceased, was sitting as a Board of Selectmen member and did things that should not, in my opinion, have been allowed, and there didn't seem to be any teeth anywhere to make sure that at least the individual owned up. Also, elsewhere in the county, recently an individual who had influence on a board. Don't know that he was actually a member at the time. Held property.
Let me interrupt here for a minute. I think the question was, are you aware of other situations that, where this policy would be in,
So the answer would be yes, sir.
right? Because I think if we bring up individual cases, we're going to cross over the line of due process.
Okay.
Thank you.
Let's see, we had, first, we have Representative Gilman.
Thank you, Mr. Chair, and thank you, Representative, for my question. My question might go a little along your lines, Mr. Chair, but we'll see how it falls out. I sit on the executive committee of the Rockingham County delegation, and my mother lives in the nursing home. So I have some control over the budget that is spent on her care. Would you see that as a conflict?
I personally would not see that as a conflict. It would, but I don't know.
Thank you.
Yes, Representative Melvin, please go ahead. You have the floor.
How come you excluded appointed, people that are appointed to boards? In my town, our ZBA is appointed by the moderator, so they would not have to follow this rule?
I think that was just something I didn't think of. I'm looking at elected officials and putting them in the same pot with the rest of us here.
Your follow-up? Go ahead.
So if we lost a member of our Board of Selectmen, and the Board of Selectmen decided not to do a special election and appointed an individual, would that individual follow under this guideline because they was appointed?
In my mind, they would, because it's the job. But when I say appointed, or where I was drawing the line is people who are volunteers, let's say the Historic Society or something like that, and they take no compensation, purely a voluntary situation. I would not see that as a potential conflict anywhere. What I'm looking at is elected officials, or in your case, what you're asking is an appointed official who assumes. To me, a person assumes a job to fill a seat for a, I don't know, say deceased elected official. I think they're subject to the same thing. They accept it and they're sworn in. You know, they're taking that job. So it's more with the job than it is the individual.
Representative Lascelles?
In my mind, there is a big need for this legislation. I'm not sure it's ready for to be processed into law. We all live in small towns, and there's always a need for, or there's always the possibility of conflicts of interest to occur. I've experienced this in our own small town, and I'm sure we all have. I'm looking at where it says disclosure required on page 1. An elected member shall abstain from participating in a vote on any matter if he or she has a known conflict. It's not just the vote. A person can exert influence by simply participating in a conversation or the discussion. So I think that person who has a conflict should not participate, should abstain from participating in any manner because they could have a conflict. The other thing too is, and I think one of my colleagues had mentioned it, is that a person could have a personal conflict, or their brother-in-law could be involved, or you have to take families involved. So my thought was, do you, for where it says disclosure required, would you agree with me that we should expand the scope of that particular paragraph to include discussion?
I would say yes to that.
Thank you, Representative. Yes, Representative Ron?
Thank you, Mr. Chairman, and thank you, Representative, for taking my question. I'm curious about the education of this bill because, for instance, in my town of Merrimack, and I'm sure there's many other towns too, we have an ethics committee and they're elected. And anyone can file an ethics complaint about someone and they investigate it. And I don't know what arrays of remedies they have. I don't even know if any charges come to them. But how would that be reconciled with your bill? Like, would we have to disband our ethics committee and it goes right to the judicial system to be charged as a misdemeanor?
That would not be the intention. I certainly would hope not. One of the paragraphs in here is that it's to promote local and county municipalities to actually write stuff. Now, write your own rules, if you will. The town of Unity doesn't have any ethics rules. And I've been sitting on that board for, like I said, 15 or more years. It's just not something we've done. However, my 2 years in the county commissioner's seat tells me the same thing. So the intention would not to be to take away your rights. The intention would be to promote those rights. And we might even be looking at your town and saying, look what they're doing. Maybe we should do something like that.
Yeah, thank you, Mr. Chair. Yeah, that's what I was going to ask is there anything that prevents a town from implementing an ethics policy and procedures if this bill should not enter into law?
I don't believe so.
Okay, thank you.
Representative Power?
Thank you, Mr. Chair, and thank you for taking my question, Representative. So when I reviewed the language of this bill in preparation for the hearing, I went back to RSA 21:48, which references the definition of a member of a local or county governing body. And it specifically cites members of select board members, boards of aldermen, school boards, and village district boards. So my question is that in your prior response to a question, you had cited that the purpose of this bill pertained to elected officials. So my question is, was it an oversight to have not included elected members to a budget committee?
That would be an oversight. We don't do it. I mean, Unity, the selectmen do everything, write the budget, there's nobody else. So I was looking at it from our own perspective.
Yes, Representative Klee. Oh, I'm sorry. Representative Van.
Thank you, Chairman, and thank you for taking my question. So, I'm going back to that whole question of what constitutes a conflict of interest. And I'm thinking about planning boards, both elected and appointed. All of those people live in town. Most of them are probably landowners. So when they propose changes to the zoning ordinance, they are affected by the changes that they propose. Does that put them in conflict with this?
I suppose potentially it could. I would think that if there was any situation like that, the individual would say straight out, I have a conflict.
Follow-up?
But they all do. I mean, think about it. If you live in town and,
Representative Van,
sorry,
question, please.
if you live in town, you are affected, are you not, by the zoning enacted by the planning board. So you are in conflict because maybe that's advantageous for you.
I think that would, yeah. What I'm looking at is the individual who may be in a major situation of personal gain, not the individual who owns a piece of property and 2 doors down something's going to happen, but it doesn't have an opportunity for him to make money on it. I can't see how this is intended to hit every single person. It's intended to keep those who can make major capital gains or other interests personal, and keep them honest and have them step up and say that they're at risk.
Representative Davis?
Thank you, Mr. Chair, and thank you, Representative, for taking my question. My question has to do with your response to the previous question, where the bill states financial or otherwise. So can you explain to me what the otherwise might be?
I suppose that could be a situation where somebody actually receives, I don't know, let's say there's a piece of property and they can receive that piece of property, but a value has not stuck on it because money didn't change hands, only the property did. Now, we know there's a value to the property, but I would think that is included in other gains.
Follow-up?
Thank you, Mr. Chair. And so said person who stood to gain in that otherwise way shall be guilty of a Class A or B misdemeanor. But when I read the statute that defines Class A or B misdemeanor, that kind of activity is not punishable under New Hampshire law by a Class A or B misdemeanor. So I go back to my previous question, which has to do with the mechanics of implementing this bill, should it become law, where it says these individuals shall be guilty of a misdemeanor. How does that happen if it's not allowed under New Hampshire law?
I don't have an answer for that. I'm sorry. I'd have to research it.
Yes, Representative Machapudi?
Thank you, Mr. Chair. Thank you, Representative, I'm here in this corner, for taking my question. I'm just trying to wrap my head around the intention. Would you believe that the intention of this bill is to enhance individual moral and ethical value system by enforcing a collective moral and ethical system?
I'd say yes.
So, just a quick follow-up,
Yes,
Mr.
go
Chair.
ahead.
So that's a very high stake in terms of to doing it, enforcing it as a collective value to implement individual changes,
Yes.
right?
Yeah.
Thank you.
Let me say that it's my sense, especially with working with the members of the committee, that they're all very careful about ethics and want to see us behave in the highest manner that we can across, not just this committee, but across all areas of government. So that's why I think you're getting a lot of questions about some of the, what I'll call softness in the bill. Let me ask you this. Has this narrative been reviewed by attorney other than the OLS team downstairs?
Only the New Hampshire Municipal Association that I know of, because I did receive a call from them, and I believe he's here to witness.
Okay. When you are, under this provision, under this ethics provision, if somebody has a conflict, is it your intention that they disclose that conflict when they recuse themselves?
Yes,
I mean, when I say disclose, not just to disclose they had a contract, but disclose what the conflict is.
I'm not sure that I'm asking that.
Okay. In the general terms, one of the reasons I think you're getting so many questions is, for example, if some committee members here sit on local government, municipal boards, town councils, or board of selectmen and so forth, and if it comes to them a vote on tax policy, where as citizens of the community, they're certainly going to be impacted by the results of that tax policy. Would it be your intention that this could be some conflict of interest between members serving in the community in a position like that and developing tax policy for the town?
That's not the intention, no. Tax policy has to happen. So it would not be the intention of trying to hold everybody hostage to that.
So if citizen A feels that they just went through a revaluation and they think that their taxes are way too high, if that motivates them to vote a certain way or to try to convince other members to vote a certain way, would that be a conflict?
I would think not.
Thank you. And given the questions you've been receiving, would you recommend that this bill be passed before perhaps Criminal Justice Committee to see if they have issues with the bill? Because of the fact that this bill does call out for criminal repercussions.
Yeah, I would actually hope that it did go before them.
Okay, thank you. I have no more questions. Does the committee have any further questions? Okay, thank you, Representative. That was a kind of a grilling. Appreciate you
Thank you.
sticking through it. Next, Kate Horgan, you wanted to speak?
Thank you, Mr. Chairman and members of the Municipal and County Government Committee. My name is Kate Horgan. I serve as the Executive Director for the New Hampshire Association of Counties, which is all of your elected and appointed officials to county government. The association is opposed to this bill, primarily for many of the reasons that you have already raised, particularly around the shall be guilty of a misdemeanor. That was very concerning to our membership. But also, all 10 counties already have ethics policies in place that they feel are aligned with best practices. I would be happy to provide a copy of those to the committee if that is something the committee would like to see. But you did raise most of our concerns already, so I will wrap my testimony and am happy to take any questions.
I would recommend that you did send those policies that you have copies of to us.
I'd be happy to collect those and get those out.
Thank you.
Mr. Chair, I have a question.
Go ahead.
Thank you, Mr. Chair. Thank you for taking my question. So approximately, we have 280 plus municipalities in the state. Would you be able to give us like more than 50% have their own ethics committee or?
Thank you for the question, Representative. I believe you want to ask that of the Municipal Association, not of the County Association.
Okay. What kind of data could county association give us?
I can send you all 10 policies.
Okay,
By
thank
the way,
you.
we do have the Municipal Association ready to speak here
Okay.
shortly.
Thank you.
Any other questions for Kate? Seeing none?
Thank you.
Thank you. Next, we have Natchez Grays. Do you want to speak to this bill?
Thank you, Mr. Chair. Nate Grace for the New Hampshire Municipal Association. We do not object to the concept of a ethics bill. A large part of what we do is provide assistance and training to municipalities on good governance, and we help them work through ethical issues as they pop up as part of our legal services side of things. So we're well aware that there is quite a lot of contention about this, but I think as illustrated by the committee today, this bill is probably not ready for prime time. There were a couple of things that I wanted to point out that weren't necessarily mentioned already. Lines 9 through 11 about the disclosure of confidential information, that is probably already captured under RSA 42:1-A Roman 2, which is the oath of office statute that relates to disclosure of information that a member might learn in non-public session. I would suggest that the committee take a look at that if they're going to consider this bill and see how those two would interact. In addition, lines 15 through 18 about the ethics policy that would be developed at the local level. There already is a statute, RSA 31:39-A, that allows a local legislative body to adopt an ethics policy for municipal-wide and gives them some pretty broad discretion about what to do there. That might be captured based on what the sponsor said already under that statute. As far as section 1 goes there, which are lines 5 through 8, it appears that the sponsor may have been intending to capture kind of the essence of a couple of New Hampshire Supreme Court cases. We only have a couple on ethical issues at the municipal level, and those are Quinn versus Concord. That's 108 NH 242 from 1967, where I guess the relevant line is, the court states, "We think misconduct in office means simply the doing of something which the officer ought not to do, or the failure to do something which he ought to do in the conduct of his office. Each case must rest upon his own facts." And I think that illustrates, as has the committee's questions, how difficult it is to capture that today. And really that idea was repeated in the case Atherton versus Concord, 109 NH 164 in 1968. I'm happy to take questions.
Any questions for NHMA? Yes, Representative Majapudi.
Thank you, Mr. Chair. Thank you for taking my question. My question to you, which I posed earlier, would it be possible for us to get how many municipalities have their own ethics rules in New Hampshire, just so that we have an idea?
I don't have a comprehensive list. It's not something we collect data on. I can tell you that it's something that's very popular in our training sessions. So, for example, we do an annual conference in November. We have an ethics section that I usually teach or have been teaching for the past several years. And we usually get around 60 or so local officials who attend that, just because it's so complicated and it's really a case-by-case basis.
By the way, those who registered for this bill, there are 6 supporters and 29 in opposition. Any other further questions for NHMA? Yes.
Thank you, Mr. Chair, and thank you for taking my question. Some boards in Exeter, it's all of our land use boards have rules of procedure which cover how a meeting is run, and part of it does do with this fiduciary responsibility to declare the conflict. Are those adequate? I know that there's one RSA that covers it for cities and towns, the one you cited. Part of this bill covers counties, and I haven't found yet similar thing for counties.
Well, ethics is such a broad area that it certainly plays into the rules of procedure because those outline the expectations of everyone involved. So when they come up, they understand, what the application process is going to be, what the appeal process is going to be, how the board's going to conduct itself. There are other parts involved too. So, one of the good examples that we've seen court cases on is if you're a board member, but you're also an abutter to a case in a land use case, and you, for whatever reason, sit as part of the voting body, that is not the right thing to do because the court has an automatic presumption that you have a conflict of interest there. And so if that were repealed to the court, you'd see an automatic reversal based on the fact that's a quasi-judicial body and there's somebody on there who shouldn't be on there. So that's one area where, we have clear law, but it does get complicated. What if your spouse is involved in something? And that's not something that's going to be, all of that's not going to be captured under your rules of procedure.
I have a question for you. If you go to paragraph Roman numeral number 1, that whole paragraph, it seems to be very specific and then slides into the very general as you get towards the end of the paragraph. For example, my question is, if we're looking to define ethics violations as any financial, in any business, including any obligation, so that's very inclusive. But then the paragraph goes on to say that's in substantial conflict with official duties. So who would adjudicate the difference between substantial and non-substantial?
I think if this were to pass as written, that would be something that would have to be decided at this New Hampshire Supreme Court, which is, of course, not something we generally want in the legislative context, simply because I don't know what substantial conflict means, and it may be the case that the Supreme Court says that's going to be an individualized basis, which is going to be problematic.
Thank you. Any last questions? Seeing none, thank you very much.
Thank you.
Our last speaker on this topic, Linda, help me with the last, Wadenstein? Wadenstein, yes, thank you, from Newport. You support the bill?
Hi, thank you, Chairman. I had something prepared, and I think I'm going to go a little bit differently based on listening to everybody's questions on this. I have been an elected official in my community of Newport for over 10 years, and have served on many different boards, and I'm a business owner as well for many years. One of the things that I just like to point out, and I'm on a school board side, not a municipal side, so you guys been focusing on the municipal side here, so I'm going to reel you in and maybe try to get you a little bit differently. Is it all right if I take this off?
Sure.
I'd like you to see my face when I talk. One of the things that I'd like to bring to point is when we all go to put our name in for a position, whether it be your position, school board position, municipal position, most ethical people look to see what the job entails. Can I do it? What's required? What are some of the processes involved? And we all have some itching about ourselves why we want to join this committee or board. That's why we're here, to make a difference. So when we go and we take our oath of office after being elected in, we all do the same thing. Do solemnly swear and affirm that I will faithfully, impartially discharge and perform all duties incumbent upon me to the best of my abilities. To the normal person, you would think that makes real sense and implies ethics as well. From there, you go to an organizational meeting where you select the chair, vice chair, secretary, And typically, after an organizational meeting where the officers have been elected, you go and you review your code of ethics or your code of conduct in some places, and you all agree and sign it. There's processes involved with policy, and you have policy committees. I would imagine it's similar across the board. If there's something that a board member would disagree with in the code of ethics, they would bring it to policy committee and bring it back to the board with suggestions. My support for this bill comes around the code of ethics, not so much about the conflict, which you all have been very focused on here, but the fact that the code of ethics is a guide of principles designed to help the board conduct business honestly and with integrity. And some of those outline missions, values, things like that. It's common sense things. So things like be prepared for all the meetings, read the material in advance, which you all have done here today. Be respectful to one another and be able to share opinions. Be informed about the decisions you're making, or if it's educational, understand what you're talking about. Those types of things. So my reason for supporting this is that there is no teeth in ethics, and the simplicity of being able to be sworn in under the oath of office or abiding by a code of ethics committee or the board itself is run by. So for instance, an example, if you have a board member that has maleficent intentions, that comes to a board with the sole purpose of being individual, an I, not a team, and refuses to sign a code of ethics and possibly just shows up and roll call and says, I'm here, and then leaves. Also gets stipend public funds for that position. They are voted in, and I know somebody over here, representative over here, was talking about recall. There is no recall for a board member, a school board member at least. So now you are stuck with a representative on a board that is not participating, is trying to cause chaos, and is making the burden of the work upon the other members, not including themselves. So when I think of code of ethics, it's kind of a no-brainer. And I understand all of your concerns about conflict. Again, you almost think that that is something an ethical person would say, especially in municipalities, if they are talking about a home that is next to them. I would imagine they would have to disclose that, I'm going to sustain because I own the home next to me, and I don't want this board's decision to be reflective upon my personal opinion. But when you have somebody that doesn't want to abide by an ethics that an official position is elected to that maintains a policy, I have a problem with that. I would imagine that the teeth of the fines is questionable, how that works, and my 2 cents for that. Am I allowed to give my 2 cents about how it might be changed?
Sure.
For me, it would be as simple as putting it in the oath of office, agreeable to rules and regulations of this constitutional law in the state of New Hampshire and by the board seated upon. And if they don't sign it, they are not sitting on that board, and giving them a time date to sign it. They have 30 days to agree to it or not. The problem is, and we all know this because you're all here and this is why we're here, it's kind of the old legal term, if it's not in writing, it never happened. So if it's not part of a statute somewhere about code of ethics, people absolutely are going to use their right to speech which I don't think ethics has a conflict to, because it encourages people to have the right to speak and listen to people's differences. However, if somebody comes on just to create conflict and chaos, I have a problem with that. And for most people, like you said, and the gentleman prior to me, and the woman, I'm sorry, forgot your name, most schools, most municipalities, most legislative bodies have a code of ethics already. But there is nothing in the RSA that makes them abide by it, and I think that's the problem that I have. So I like that there's some teeth in it. So I changed my focus a little bit, but hopefully you better understand that. So
Thank you. Are you willing to take some questions from the committee?
absolutely.
Anybody have questions for Ms. Wadenstein? Yes, Representative Gallagher.
Yeah, could you just spell your last name for me, please, for my personal note-taking purposes?
Sure, thank you, Representative Gallagher. It's Wadensten.
Okay, thank you.
I have a question. How do you decide, or what would you decide would be the difference between disclosing an issue versus recusing yourself on an issue?
Well, I'm no legal aid here, so I can only give you my opinion. I think that if you disclose or recuse, it's kind of almost the same thing, because if you're not going to vote, it's a moot point. But if you want to expound upon it, I think that as having sat on an elected official position as long as I have, in small towns like we have in New Hampshire, you can bet your bottom dollar that there's somebody that's going to point out why you had to recuse yourself. So it's better just to say why you're recusing.
Well, let me rephrase my question. If somebody has a problem with themselves and they decide they're going to fix that problem by disclosing the issue to the audience and the board members that they're with the intention that they are going to vote on it and discuss the issue as long as they disclose it, versus I'm not going to participate in the issue, I'm going to recuse myself. In fact, in some cases, they leave the dais and sit in the audience. Do you see
Yeah.
a problem with either one of those? Or?
Well, I do and I don't. If that were in my position on my board, and I've been chair for a long time, one of the things that I welcome people to come on boards with purpose. I would then say to that person, let's put it to committee and do research. And then the committee can bring back recommendations. That way it involves the member that has an issue, but it also involves other people, and it's a we versus an I coming forward with a suggestion.
Maybe I didn't hear you when you started. What board or commission are you on now?
I am on the Newport School Board. I've been there a very long time.
If someone came forth and said to you, a fellow member of the board said, I have a conflict, do you require them to reveal to you what the nature of that conflict, or is it just okay for you to hear that they have a conflict and they've decided not to speak or decided not to vote?
Well, I think it comes down to a personal's true north, because I wouldn't know that unless you disclosed it to me. If you disclosed a conflict to me, I would absolutely encourage you to abstain or recuse for those reasons. And ethically, for my own true personal north, I would have to bring that forward and say, our board member so-and-so, I think, needs to recuse themselves because they've already disclosed a conflict to me.
If you're looking to ask the community to vote on the next teacher contract, which I'm sure you've done quite often, and there's a member on the board who has a relative who is a teacher, is that considered a conflict of interest?
Well, I believe that there is already some statute somewhere, if I'm not mistaken, that talks about small boards and small communities where it is often that you will find a husband or a cousin on a board. So if, in particular, this has come up with us, so I will give you that particular example. The person, if the person is on the board and they are voting on a teacher contract, they would recuse themselves from it because of their marital status with somebody.
Thank you.
Yes.
Are there any other questions? Seeing none, thank you very much for your testimony.
Thank you very much for your time.
Is there anybody else from the audience that would like to testify on this issue?
Mr. Chair,
Yes.
question for the chair. So can we, how many on blue sheet for or against on this?
Yeah, I mentioned that. Let me hit it again.
Just the blue sheet or online? You're aggregating everything?
This is the advocates for everything. We don't have the blue sheets anymore. What? We had 6 in support and 29 opposed.
Thank you. And this could change till the end at midnight tonight. Thank you.
Okay, next, we're going to close the hearing on 1161 and open the hearing on House Bill 1179. Representative Yurkala, you going to introduce this bill again? Are you going to again introduce a bill?
Thank you, Mr. Chair.
Yes,
And
go right ahead.
thank you. Thank you, Mr. Chair and members of the committee. Again, for the record, my name is Representative Josh Yurkala from Fremont, Danville, and Brentwood. I am introducing HB 1179, which is relative to protest petitions protest petitions are a form in which some members of a community may be allowed to change the threshold for passage of zoning changes from a simple majority to a supermajority. And some of the policies that we as a state are passing and locally are trying to address the housing shortages and affordable housing and just access to housing in general. And what this bill would do is, if we are trying as a town or as a community to allow to change our current policies to allow for more density or more affordable housing, or complying with new laws that require such zones to exist. When we change the law, sometimes we need to change the local zoning ordinance to comply with the new law. There is the potential that someone might use this protest petition to make it harder for us to comply with the law or make our communities more affordable. And so this bill is just trying to say, hey, if we're trying to address the housing crisis in New Hampshire and we're trying to comply with a law that is now allowing, increased density of development or reduced dimensional requirements of lots, or that not be hampered by a supermajority vote requirement, and that a simple majority should be allowed to pass those changes. And that's all that I have for this bill. I'm happy
Anybody?
to answer
Yes,
questions.
Representative Van?
Thank you, Chairman, and thank you, Representative Viola. So I see what you're trying to do here, but let me ask a question about the opposite side of this. Suppose your town has adopted an ordinance that allows for smaller lot sizes. After it's been in place for 5 or 6 years, a group of citizens suddenly discovers that it exists, files a petition warrant article to eliminate that dimensional standard. So, and another group of citizens files a protest petition to say, okay, if you're going to change this, you got to get 2/3 majority. So it seems to me that the whole protest petition, 2/3 majority, simple majority, can work in both directions. So what's your response? And I did not make that up, by the way.
Thank you for the question. Could I ask for some clarification on the question? When you were describing the situation, you suggested that there was increased development allowed in a certain section, and someone did a warrant article to remove that maybe zoning ordinance, or they're trying to remove any dimensional requirements at all for that area?
No, they're trying to
Increase?
They're trying to remove the already passed zoning ordinance, which allows for smaller lot sizes. So it's a dimensional change.
So they're trying to increase the requirement of size development, and there is, and so currently under our statute, you would be able to have a protest petition and make that that size increase subject to 2/3 majority requirement and not a simple majority requirement. And under this law, this would not change that. However, if they were to do the reverse, if the planning board or a zoning board, or if the planning board or a petition if this bill passed, if they tried to put in increased density development, they would not be allowed to do a protest petition for that. Is that kind of your question?
Follow up.
Yeah.
Well, then I think that you need to clarify that this does not apply to citizen petition articles. Because as I read it now, a petition warrant article that changes dimensional standards could not be protested. And I don't think that's your intent.
Are you saying that currently that citizen warrant articles are not allowed to be protested?
No, currently citizen warrant articles are allowed to be protested.
Okay.
Under the way I read this, if it passed, if a citizen petition warrant article changed dimensional standards, it could not be protested.
If it reduced the size? No, under...
If it addressed dimensional standards at all, sorry.
Yes. Okay. So my understanding of the question is that if I agree that with this proposed change, you wouldn't be able to protest any warrant article that was a citizen petition. And for changing dimensions in any direction, and I don't believe that to be the case because the bill doesn't specify what the amendment to the zoning, like the method of it getting on to the ballot, is not specified in this bill, and it specifically only addresses reductions of dimensional requirements and increase of density. So it would only be applying to ones that were trying to, let's say, remove the increased density development. It would not, this would not apply to someone trying to implement increased density.
No, but I'll take it up with Representative Yokola later.
Sorry.
Thank you, Mr. Chair, and thank you, Representative, for taking my question. So I just want to be clear and understand what this bill is proposing to do. So I understand lines 3 and 4 as written. So just to be clear, if there was a petitioned warrant article that sought to, the subject matter is to increase dimensional requirements or decrease allowed density of development. So it's just the inverse, that we're just switching the adjectives here. So the subject matter still pertains to dimensional requirements and density of development, but it's what direction are we going in? So to be clear, the vote threshold to reduce dimensional requirements or decrease density, that would still require the 2/3 vote threshold. Is that correct? So we're taking the subject matter and...
That was a question.
Sorry.
Thank you for the question. As I stated before, the method of getting the amendment on the ballot is not really relevant to this bill. However, in the very last statement that you said, I thought that you were trying to reverse the language in your question by saying increase dimensional requirements and decrease the allowed density, but then in your final restatement of it, you said reduce dimensional requirements and increase and decrease the allowed density, which didn't make any sense to me. So I'm going to answer the question as if it was completely reversed. And I think that this bill, if you were to increase dimensional requirements and decrease the allowed density, that this bill has nothing to say about that, because it's only talking about reducing dimensional requirements and increasing allowed density, which is the purpose of this bill, and so that we can address the housing crisis. If you're trying to increase it, increase the dimensional requirements, I think that that the current system is fine.
Would you like a follow-up, Representative?
No, thank you.
Are there any other questions? Representative Mangiapudi.
Thank you, Mr. Chair. Thank you for taking my question. I'll put it in a very simple term. Are you trying to address one specific issue with the sledgehammer? You're trying to nail one nail with the sledgehammer.
Thank you for the question. No.
Are there any other questions for this representative? No, I see no. Thank you very much for your
Thank you.
testimony. Is there anybody in the audience that would like to testify on this bill? Okay,
Thank you. I'm gonna
Mr.
close-
Chair, could
Yes.
you tell us what the online?
I'm about to
Thank
do
you.
that. On the House remote testimony, we have 0 support and 1 opposed, and that's House Bill 1179. And blue sheet is, thank you. No one at all on the blue sheet. I'm going to close hearing on HB 1179 and open the hearing on House Bill 1183. And that is relative to the calculation of property taxes for residents, I'm sorry. Just give me 1 second. Yes, that's relative to calculation of property taxes for residents 75 years of age and older. Is there anyone who wants to introduce this bill?
Good morning, Mr. Chairman and members of the committee. My name is Representative Dennis Thompson. I represent Coos County District 1. The bill today is relative to the calculation of property taxes for residents 75 and older with respect to their school tax portion of their property tax. And what the bill proposes is to, at age 75, is to reduce their school portion of their property tax by 5% per year for 5 years, for a total of 25% reduction, which would last for as long as the person lives or their spouse owns the property. I was contacted by the Municipal Association a couple of days ago and asked to provide them with an amendment, or to provide an amendment to clarify a couple of items. Number 1 would be on page 1 of the amendment, if you have it, lines 6 and 7, which would allow the town to adopt or rescind this discount on the school taxes. On line 11, it's listed as 5%. That's correct. It was listed as 10% prior. And that also spells out the discount over the years to a total of 25%, where that would continue on. The last change was on the initial bill, it would have taken effect in 2022, which we all know can't happen. So we've changed that to 2024 to allow the tax collectors and the DRA time to come up with the forms and to process any claims in the first year. If you have any other questions, I would be happy to answer them if I can.
Okay, Representative Majori.
Thank you, Mr. Chair, and thank you, Representative, for taking my question. I'm curious why there is no means testing for income in this bill.
Well, because I thought about that a lot, and I've seen some in the past that had, and there are some other bills that allow for elderly exemptions. I think one of them is veterans exemption. The reason I did that is my feeling is that these people, and particularly in my district, we have a much older group of folks who have supported the public school systems their entire lives. And it seems like it's time to give them a break. We have many people up there that are on the verge of losing their homes that they've lived in for their entire lives. We have other people that live on $1,000 a month Social Security, and the taxes continue to go up, and generally they go up, particularly in our area, they go up because of the schools. I know in my particular town, we've not had a tax increase with the exception of the school district's request in quite a number of years. The town has kept their budget flat. in order to try and assist the taxpayers with this. So my feeling is, if someone has more money, they probably also have a larger property and a larger house. And this is restricted to 2 acres, the house and a garage. Any additional land they own would not be exempt. It needs to be their primary residence. They need to meet an occupancy requirement for how long they've lived in the town. And with respect to a spouse, they'd have to be married for a minimum of 10 years. So I didn't write that into the law for that specific reason, that we do have some people, I mean, if they've had a $500,000 home all these years, they've paid substantially more taxes than someone who has a $100,000 home. So I think they deserve the same percentage of decrease. And it appears that the people eligible for this statewide would be just over 9%. So the impact obviously, and this was, I hadn't thought of it, but it was pointed out to me by Ms. Heck from the Municipal Association, that the impact of this is going to not be on the schools. It's not going to hurt the schools at all. Their budgets will remain the same as they need for the following years, but it will raise the taxes on the taxpayer, the overall taxpayer, a little bit. And
Representative Suspender, somebody got a phone or something on?
I apologize, Mr. Chair. I'm in the process of putting that on mute, sorry.
Go ahead.
So that's the reason behind that. No problem.
Okay, Representative Davis.
Thank you, Mr. Chair. I have 2 things. One is a request to the chair that we ask for a fiscal note on
Okay.
this bill. We have several tax credit, tax exemption bills that have no fiscal notes.
Okay, when we get to executive section, we can take a vote and decide to send that to the finance, if you would
Thank
like
you,
to do that. And I
Thank
will
you,
make that
Mr. Chair.
motion if you'd
Thank
like.
you, Mr. Chair.
Thank you.
And my question, thank you, Representative, for taking my question. As sometimes happens in life, older people marry very much younger people, and they may stay married for a very long time, and the younger person may have children in school. So if I'm 75 years old and I marry someone who is 50 and has children in school, and I pass away, but I have qualified for this credit, and my spouse qualifies, I'm not yet 75, I still have children in the school, yet I am still getting the credit? Is that the way this would work?
Thank you for the question. My reaction to that, I guess, is that if the spouse is not 75, they'd be eligible for the tax credit while they're married to the person that is 75 or older. If that person should pass away, then I would think the spouse would have to reapply for a tax credit. If they're not 75, they would not be eligible for it.
Follow up, Mr. Chair?
Go ahead with the follow-up.
Would you be amenable to amending your bill so that it's specified in the bill? Because under the current
Yes, I would.
text,
I would
it's
be.
ambiguous.
I would be
Yes.
amenable to
Thank
that.
you.
Representative Rung.
Thank you, Mr. Chair, and thank you, Representative, for taking my question. I'm curious on line 6, it says a town or city may adopt or rescind the property tax credit established under this section by the procedure of RSA 72:27A. So it would either be by a vote of the, I haven't looked up that RSA, but would it be by a vote of the people or a vote by the selectmen or the town council or
It
city
would be the
council?
taxing agency, so the selectmen of the
Okay.
city, depending on where it is. There is also an appeal process that's stated in statute that they can appeal the decision if they'd like to.
Okay. Follow up, Mr. Chair?
Go with the follow-up.
Okay, thank you. And if this bill was enacted, so the tax savings that the person 75 or older would enjoy, that would be made up by other taxpayers, correct?
That is correct.
And would that be a burden for them?
I don't believe it would. I mean, it's going to depend on the value of your property and the quantity of people that apply for this credit. And they do have to apply for it. It's not automatic. There'll be a DRA form that will be generated for them to apply for it, and it'll be up to the town, either the tax collector or the selectman, to decide whether it's a legitimate request or not. But if you're 75 and you own the property and meet the other criteria, I can't see how it wouldn't be a legitimate request. But they do have an appeal process as well if they don't want to, if the select board or the tax collector doesn't want to grant it for one reason or another.
All right, thank you.
Representative Cleage.
Thank you, Mr. Chair, and thank you for taking my question. I get this question all the time, so I understand, I have nobody in the school, I've been living in the city for this many years, why can't I get a break? I will admit that the lack of means test does kind of stick with me, but putting that aside, what about someone who's been living in their municipality for 40 years, namely me, not quite 75 yet, and but low income? How do you explain that to them, saying, versus someone who may have only lived in the city 10 years but meets the 75 age requirement and has a $2 million home?
I'm going to have to think about it for a second.
Okay,
but
sorry.
My initial reaction is that we can't draft bills for every eventuality. It's just not possible. And I just think that if there's a standard set down that you need to live in the town for 5 years minimum, and you need to be over 75 years old, I think there are going to be some chances where low-income people, I don't know that they'll be hurt by it, but until they're 75, they're just not eligible for it.
Thank you.
Representative Manchaputi?
Thank you, Mr. Chair. Thank you, Representative, for taking my question. My question is, taxes that help with the schools. It's a collective effort.
Correct.
If you want a good community to have contributing members in the community, we have to provide educational system. So if we are making exception because we are 75, I don't have kids in school, are we going to next make an exception for families who are moving in but don't have children? Why should I pay for this? And I don't have, I live by myself in a corner and I don't use the roads. So I'm not going to pay for the roads. So are we going to make exceptions? How are we going to answer that?
Under this statute, there'd be no exceptions for people under 75 years of age. And frankly, my reason for doing this is many of these people, if they've grown up in the public school system, and most of them have, and have had children and probably grandchildren at age 75 that have been in the public school system, they want to support the schools, but in many cases, they're just not able to do it and make ends meet. Living on Social Security, depending on what your particular circumstance is with Social Security, you're not going to get a lot of money to pay your taxes to begin with. And this seemed like a reasonable way that after people had paid all these years, that they should get some sort of a tax break. We're not discounting their property or the value of their land outside of the 2 acres the house and a possible garage might sit on. So they're still going to pay the full tax on that, including the school tax portion. It's just on their primary residence.
Follow. Thank you. What if, in a transitional or transient population, in terms of, I lived in a different community, I paid the taxes, my kids went to the public schools and stuff, then I moved to a retirement, and I turned 75, and I come to New Hampshire. Now I can say, oh, I can get the discount. I haven't paid into New Hampshire, but I came here because it's attractive. So are we going to make more people come here because it's,
Well,
we don't have sales tax, we don't have income tax, we don't have property tax, so this is a tax haven?
Well, again, you have to have lived in your primary residence for a minimum of 5 years before you'd be eligible to apply for the tax credit. Beyond that, I have no idea whether it would attract people to New Hampshire. I would pretty much say that most of the people who retire try to migrate south, not up here, particularly with the storm we have coming. That's really all I can say about that.
Thank you, Mr. Chairman. Thank you for taking my question. On line 9 of the first page, it says that it must be owned and used as his or her residential real estate. On line 15, it says if the real estate is owned by the person's spouse. Is this an exception to the requirement on line 9?
First of all, I got to put my glasses on.
Oh.
Are you talking about on the bill or on the amendment?
On the amendment. I assume we're talking about the amendment.
Okay. It would be, okay, now I've read this. Could you repeat the question?
All right, on line 9, it states that the property is owned and used by as his or her primary residential real estate. And then on line 15, it says if the real estate is owned by the person's spouse. So, it seems that there's either a contradiction or an exception.
Well, I think the way I wrote that is in one of the previous representatives asked about the age of the spouse. It was intended to mean that if they're married to someone and the property is in their name, those two people live in the domicile, but they'd both be, if they're paying the taxes, they'd both be eligible as long as one of them is alive and over 75. But if that...
Follow up, please. But, like I said, if you look at the requirement on line 9, it says it has to be owned and used by as their primary real estate. But if it's not owned by the person that is qualifying, then, like I said, is this an exception or is it a contradiction?
...75 years of age, who is liable for the property taxes for the property owned or used as his or her residential estate, or residential real estate. So it says that the 75-year-old person needs to be the person liable for the taxes. If you have your father or your grandfather move in to your home, if you're paying the taxes, you're not liable for the credit for them. It doesn't answer your question, but OLS wrote this. with these other statutes in mind. So I would have to go back and ask them.
Thank you. So, do you believe there's a contradiction? Or is it, or like I said, is it an exception? No, I don't think it's clear.
If the real estate is owned by the person's spouse, the couple must have been married for at least 10 consecutive years. So, no, I don't think it's a contradiction. I think if, it may very well be a contradiction.
Thank you.
If it's owned by the person's spouse, yeah. I'll go back to OLS.
Thank you, Mr. Chair, and thank you, Representative, for taking another question that I am trying to figure out if it's actually a question, but this municipal and county government has several of these bills that are exemptions, and one of them is an elderly exemption, and I'm not sure that there's going to be a question in here, so I'm trying to figure it out. Do you think there should be a reconciliation somehow between these bills? Because we have another elderly exemption, which I am going to be elderly, according to that one, at 60 years old. But this one is 75 years old. The other one is a 1-year residency requirement. This one is a 5-year residency requirement. Do you have any idea? I guess the question is, do you have any idea how we can reconcile which one of these is the right one? And that's why I'm not sure that I can ask that question, because with all due respect, there's no way you could know the other bills that we have in front of us.
Right,
All of them.
I've not read the other bill, but I'm over 60, and I've never asked for a tax credit because of my age, and don't expect that I will. But I'm probably better off than many of the elderly people in our state. And I would not like to see this bill combined with that bill. I just think that 60 years old is way too young to be asking for an elderly exemption. Although AARP gives out cards now when you're 50, so.
Thank you, Mr. Chair, and thank you for taking my question. I'm going to go back to the means testing, and maybe I don't even have to do that. But if you have someone who owns a $400,000 house, who's 75, doesn't have their kids in school anymore, and is not paying the school part of the whole tax bill, but you have someone who's living in a $40,000 manufactured housing unit and has 2 kids in school, where does the exemption for the person with the larger property end up? It's going to end up in that person with the smaller property, is it not?
I don't know the answer to the question. I wish I did. I think the way that I approached this was that if the value of your property was higher, you've obviously paid much more in school taxes over the years. If the value of your property is, I don't want me to sound contrite, but minimal, then you've paid a lot less in taxes. And yes, if this goes through and there are any number of these people that apply for this, there will be an additional amount added to everyone's property taxes in the town, and it's indeterminable what that will be, because we have no way to know how many people are eligible in a particular town and how many would even apply for it if they were eligible. As you well know, we pass laws here every year that no one in the state ever hears about or is made aware of. So hopefully this won't be one of those bills if it makes it through, but I think it we need to give these people an opportunity to save some money. And this seemed like the best way to me.
Thank you, Mr. Chair, and thank you for taking another question.
No problem.
Following up on what my colleague asked about other bills before this committee that deal with tax credits or tax exemptions, would you feel that it would be right and proper if all of the elderly tax exemption or tax credit bills passed, that they be cumulative? So for example, if this bill would pass and somebody applied for this tax exemption or tax credit and received 20-25% off their property tax bill, but they also applied for and received an additional exemption under another law that passed, should those two be added together to make an even larger exemption? How would the state, where would it end?
Well, I think that's where having the section in that allows the tax collector or the selectman to determine whether the tax credit is able to be applied for. I would think that most towns or tax collectors would not consider more than one exemption. They would go to whatever the greatest exemption was for that person if they applied for that exemption and give it to them. If someone applies for a veteran's exemption because that works better for them, and most of those people don't have to be over 75. They can be much younger and still get the exemptions on the laws that exist currently. I don't know about the bills before the committee currently, but I think that the opportunity to decide that is left with local government and, you know, probably a consultation between the selectmen and the tax collector. And if they're doing their job, in my opinion, they should be pointing people to whatever the best deal for them is, tax-wise, and approving that.
Thank you.
And there is always the right to appeal.
Thank you, Mr. Chair. Thank you, Representative, for taking my second question. Have you looked at how, specifically because you're carving out an exemption for school taxes for people with 75 and older, how would it impact communities where 2/3 of the population is elderly or older, and their school system still needs support, and we still need to attract younger folks to live in that community? Is this making that accommodation for the community to still function and thrive, or is it going to make it constrict and kind of eliminate the younger community members coming in?
I don't think it will. One of the reasons that I phased this in over 5 years, they get 5% the first year, another 5% the second year and down, so that the tax base has a chance to adjust to that tax credit, whether there be a lot of people in town or not a lot of people. And with Ms. Heck's permission, I will use your example of a $400,000 home. Ms. Heck did the math and came up with an example that she felt that in an average town, if you had a $400,000 home, which I guess is average now, that over this period of time, it would cost you about $249 additional in property tax to make up for the credit taken out of the school tax. So it doesn't, if you're paying taxes on a $400,000 home at $25 a thousand or whatever the tax rate might be, $249 is a pretty small price to pay. The other thing you have to understand is most of us have parents or grandparents that at some time here in the future are going to qualify for this deduction. So I don't think we're not picking on the younger people. We're just asking them to do something they're probably already doing by supporting in some way their parents or their grandparents. And I'm not talking about necessarily financially, but it's a easy way to do it, easiest way I could come up with to do it. And I did look at the other bills that allow elderly tax exemptions, and some of them are convoluted, I think is the best word. And I think there are a lot of people that just wouldn't understand them. This bill, at least, you know, a 75-year-old person can read it and understand it. And as far as attracting younger people, my goal is to attract younger people to the state, particularly where I live. We have currently have a factory that needs 410 people, and they can only attract 160 because we don't have any young people. And when you look at the newspaper every week, there are more and more people that are being eliminated just by attrition. I'm trying to keep the people there that are there in all the towns in New Hampshire, not just in my district.
Thank you for taking, answering my, thank you for taking my question. I'm going to give you a scenario. I'm 75 years old, and I have less than 2 acres, but I have a commercial business on my property, or I got a home-based business. How would I fit into this? Or wouldn't I?
Well, I would guess it would depend on what your zoning is. If your zoning considers it a commercial property, then it would not be eligible for this. This needs to be a residential use.
Follow up? What if my property is mixed use?
I would guess that would be up to the town to determine whether or not to apply that credit to that.
Yes, thank you, Representative, for taking yet another question from me. What if I'm 75 years old and I've lived in my home for 5 years, and I have children in the school because my children are not able to care for their kids, and so I am serving as their parent?
It's just another one of those many scenarios out there that you can't anticipate. And I guess I would have to leave that up to the taxing authority as to whether or not they would allow the exemption. My gut reaction is that I'm sure there are quite a number of people in that position currently, but those children, we're not talking about eliminating the school tax on any of these people. At the end, at age 80, they're still going to be paying 75% of the taxes that are owed for the school portion of their tax bill. So that we're not giving up that much. What I'm trying to do is give them a leg up on being able to stay in their home till they're 80 and be able to buy food and heating oil and whatever. And granted, not all elderly people are in that position, but as I said before with the previous question, people that are wealthier are probably living in much larger homes and own more property, and they're paying a much higher percentage of tax than the people that I've targeted this bill to.
Thank you.
You're welcome.
Any other further questions? I have a question for you.
Yep.
At the end of the amendment, it talks about the appeals process in case someone's refused an exemption.
Yeah, that's,
appeal for refusal to grant the exemption. I guess my question is, do you think it's reasonable that local municipalities are going to refuse exemptions once the exemption's been determined to be in place by the state?
I'm sure it happens all the time. I know of two particular instances in my town where it's happened. And I think the people dropped it. I don't think they appealed, because I did ask the tax collector about that, if they'd had any of those issues. And I think that if they qualify for the tax under the RSA, what reason would the town have for turning them down, other than, as the representative had said, they'd applied for a different tax in the past, a different
How would you
credit
deal
in the
with
past.
if the town decided that they couldn't afford to give these tax exemptions out, and they made a decision that they weren't going to allow any more exemptions for the next X period of time because there was too much stress on their tax rate?
I think we'd be talking about a court case, because there is an appeals process, and it does mention the Superior Court in there. I think that's where we'd end up. But you have to understand that even though we're giving these people this exemption off the school tax, that money is going to be made up by all the rest of the taxpayers to replace that budget for the school. And I think probably we'll find out that, again, in the figure 9% comes to mind. If there's only 9% of the taxpayers in the state that are eligible for this, and many of them won't take it, I certainly would not. Then I think we may be down to 4 or 5% of people that would actually take that. And I think that the effect on the tax rate would be very minimal.
Any other further questions for the representative? Seeing none, thank you very much for your testimony.
I thank you very much for your time, all of you, and
I'd like to invite Catherine Heck to provide testimony. Catherine, you've mentioned that you have a comment, but you didn't mention whether or not you had any preference for or against the bill.
Hopefully my testimony will clarify that, sir. So my name is Catherine Heck. I'm with the New Hampshire Municipal Association. Good morning, Mr. Chairman and committee members. Thank you for allowing me to speak today. First, I would like to say NHMA opposed the original version of this bill based on the fact that there was no local option, and we typically do not support extended exemptions or new exemptions being created, as it does have a burden on the municipal tax base. However, this is a school-specific issue, so we took no position on that. It was outside of local control. The amendment has addressed the local control issue, so now we are neutral on the bill because we have some clarifying questions that I have discussed with the representative who introduced the bill. I first wanted to say that based on some discussion you've had, I would like to address that RSA 7227, which is the adopt and rescind provision, allows the legislative body to adopt this. So that would go to a town meeting vote, which was questioned earlier, unless you are, of course, the city council and then the legislative body. There's also the ability to rescind it. So exemptions weren't being able to be met, as to another representative's question, because the town just couldn't take any more exemptions, then the legislative body should most likely rescind that they have this exemption in place. The second thing I would like to clarify is that the example that Representative Thompson gave for the $400,000 house and $249 was based on my community at the maximum exposure of the 50% discount in the original bill. So that's how that math was done, using an 18% average population of people 75 or older in New Hampshire. So those are based on some average metrics, just doing some quick math with my own tax rate, because clearly every homeowner will have a different effect based on their town's tax rate and, of course, their home's value. So I wanted to clarify where that number came from. It's certainly not a statewide number. It's very specific. And that's my community and my school district, based on all of that information. And finally, our clarifying questions would be, first, does this exemption, is it in addition to the other elderly exemption that currently exists? And the second one is the percentage tends to cause a little bit of an issue when trying to set the tax rate. All other exemptions are based on a dollar amount that the legislative body adopts or the state mandates. It's a specified dollar amount. So when the town files its MS1 form in September in order to set the tax rate, and the school districts have to file their MS24 and 25 to the DRA, all exemptions, revenues, and credits have to be spelled out in dollar amounts so that the tax rate can be set. If it's a percentage, we won't know what that percentage could possibly be to set the tax rate. So that is another area that we are concerned with because we're not sure the legislation addresses how the tax rate could be set as the bill is currently written. And I will end my testimony and take any questions that you might have at this time.
Any questions for Catherine? Seeing none, thank you very much for your testimony. Oh, I'm sorry, Representative Powell, I didn't see you.
Thank you, Mr. Chair, and thank you for taking my question. I'm just trying to formulate this question here on the fly. So it's with reference to, you had touched upon these cumulative tax credits and exemptions. So to be clear, is it true that the qualifications are clearly specified, the criteria in statute, and in fact, it would not be up to the discretion of a tax collector or a town official to grant that apart from the clearly defined criteria in statute?
Correct. The statute determines who is eligible for an exemption.
Follow up?
Yes, go ahead, please.
Thank you, Mr. Chair. So therefore, unless a particular tax credit or exemption specifically says that it's limiting and there's language within it, that these could in fact, such tax credits could or exemptions could be cumulative.
That is my understanding, and that would have to be clarified.
A question, with this cumulative tax, I'll say refund or elimination, are you aware of any communities that now have people of this age in a tax situation where they pay no taxes to their community?
I am not aware of such a situation.
Is there any further questions? Yes.
This is going to be a roundabout way to answer your question. Would you believe that Nashua has over 300 taxpayers that are not paying any taxes due to elderly tax exemptions?
I would actually believe that.
Thank you.
Okay, seeing no further questions or comments, I'm going to close the hearing on HB 1183.
Thank you.
I'm going to have one more hearing, and then we'll fade into lunch. But we're going to go on to HB 1184, which is the authorizing the establishment of revolving funds. Representative Lang, you're going to introduce this bill?
I am. The prime sponsors over in Judiciary, and apparently they're trying to exec like 40 bills or something. So yes, he asked me to come over and introduce.
Okay, thank you. Your floor is yours.
Thank you, Mr. Chair. Thank you, members of the committee. The bill's pretty straightforward, and I'll give you, it's a little broader than actually we intended when we did this bill. This bill came out of the idea of, if you have most of your towns, you know that a lot of towns have established revolving funds around police details, where a fixed amount of money is put into to kick off the account, and then after that, all the revenues received are put into that account, all the expenditures are taken out of that account, and then any net profits, for lack of a better phrase, are used to buy police equipment, vests and guns and ammunition and all the tools they need. We found out counties can't do that. That apparently we're not actually, there's no legislative authority to create a revolving fund. You can create capital funds, but you can't create a revolving fund like this. And so we wanted to do that because in Belknap County, which I apologize for the craziness of Belknap County again, but again, in Belknap County, we allot $20,000 to our sheriff's department for the purposes of police details. And when he runs out of that money, he can no longer do police details. All of officers just don't apply and work in other towns and road details and all of that kind of thing because there's no more money in the line item for it. And so when we went to try to fix that, this is what we found, was we needed to create a revolving fund and have the county creating a revolving fund to allow that to happen. The drafters at OLS realized that the language was also missing in city funds and I think it's village districts. And so they tried to keep everything uniform. Where towns it's allowed, it wasn't allowed in those other areas, so they wrote one bigger bill to include so all political entities could create revolving funds. So in short, that's the bill. They use the same exact language that's in the town statutes, I think it's the 35 chapter, to create the county, village district, and city language as well. The way the fund works, if you're not familiar with the towns, is that it would be a vote of the governing body to establish the fund. In that vote and in that motion would have to be the purpose of the fund and also the expending authority for that fund. So in most cases in towns, it's the selectmen. In this case, it leaves it to be, it could be the delegation, but it also more than likely will be the county commissioners. In this case will be what the motion would look like. So I'm happy to answer any questions, but again, that's kind of the basic of the bill. It's more of a housekeeping cleanup bill to put all the political subdivisions on equal footing. And again, to take care of this particular need that we found out in counties, that we can create a revolving fund for police details and let them basically be self-funding for some of their equipment.
Representative Lang, is it your experience that these police details pay for themselves in terms of the amount of money collected from the most often construction site or the whatever the details for?
Thank you for the question, Mr. Chair. So yes, it's my understanding. So I'm a retired. I'm not retired. I'm a former police officer. Spent over a decade on the job. I took all my money out into computers and made a lot more money. But when I was a police officer, the fees that they're charged are always looked at to make sure that they're not costing the municipalities money, but they're either breaking even or making a slight profit. And so in the case of Samberton, my town, where I'm the town moderator, ours has been, we've been able to pay for police improvements. So again, replacing bulletproof vests, replacing safety equipment in cruisers and those kind of things. And we've been able to use what little bit of overage that shows up in these funds to be able to pay for that and not affect the taxpayer directly.
Any other questions for Representative Lang? Yes, Representative Rung?
Thank you, Mr. Chairman, and thank you, Representative Lang, for taking my question. What's the difference between a revolving fund and a capital reserve fund?
So my understanding when I read the chapter was that a capital reserve fund is usually used for building and facilities, whereas a revolving fund can be used for other purposes.
Okay, follow up. Where I'm from, Merrimack, our town operates, most of our budget is like 22 capital reserve funds. And we like that because it keeps our tax rate stable. But every year when we go to, when we have town meeting, we have to approve any money going into it. And would that be the same be true with the revolving funds?
It would not, because we're not actually, so in the difference between capital reserve fund is most time you're using taxpayer dollars to fund it, either through an unexpended fund balance is usually where it comes from. Whereas this is not using taxpayer dollars. So once the fund's established, the money coming in would come from the details, the money going out would be going to the police officers, and so there's no tax dollar expenditure.
Oh, okay, so revolving funds are only funded through non-tax revenue.
Correct.
Okay, thank you.
Representative Davis?
Can you give me some sense of what that non-tax revenue might be?
So again, looking at Belknap County, and again, that's the representative I have, is the reference I have. Belknap County, we put $20,000 into we annually budget $20,000, which does come from tax dollars, into the police reserve fund, and I think the number last time we got back was a little over $40,000 through the various, because it also depends on the detail. So some are paid more than other details, so it's not a flat number we can.
Representative Lang, talking about, I see some confused faces, the difference between revenues and expenditures?
So, right, so the difference is, again, so on the revenue side is what we take in, so I'll use, again, Belknap County, we have Bank of New Hampshire Pavilion, which hires a lot of police officers during the summer for their concerts to be able to maintain security. That's an outside, considered an outside detail, and the town of Guilford manages it, and they put money in, but again, the way it weirdly works is that, in this case, is that the town of Guilford manages it. We pay, the Bank of New Hampshire pays the town of Guilford, who then pays the police officers, but the county pays the police officers too, so for their hourly rate, so to speak. They pay first and then later on collect the money. So it gets kind of messy, and the idea is with this reserve fund, with this revolving fund, that would not be the case.
Any other questions? Yes, Representative Majapudi.
Thank you, Mr. Chair. Thank you, Representative, for taking my question. Once established, this continues in perpetuity. Is that your expectation, or are you hamstringing the future boards or?
So again, once the fund is established, the idea will be self-sustaining, right? So the money that comes in from the revenues from the special detail will be higher than the expenses going out to pay the police officers who are working that detail. So again, the idea is it's a self-sustaining fund. It'll keep the money coming in. We'll pay for the future. There'll be a one-time expenditure for the county to be able to start the fund off. And then once that's done, there'll be no more expenditures from county, no more tax dollars going into it.
Follow-up.
Yes, follow up.
I'm looking at page 2, line 22, facilitating transaction relative to group net metering, and before that, energy conservation. So all these different line items, are you going to be establishing, is the intent to have different revolving fund for all these?
Thank you for the question. Again, this was taken from what's allowed by towns, so they cut and pasted everything that was in towns into all the other political subdivisions, so it was all equal. So again, if you were to establish a fund, you have to specify the purpose, and that's in there. So again, if you wanted to do one for facilitating transactions relative to group net metering, that would be allowed, but you would set up a fund specifically for that with its dedicated purpose and its dedicated persons who are allowed to expend from that fund.
Yes, Representative Power.
Thank you, Mr. Chair, and thank you for taking my question. So I want to be assured that with regard to these revolving funds, no monies shall be raised nor and appropriated by or through taxation. So I'm looking at page 2 and line 25, where the language references and any other revenues approved by the legislative body. Now, I understand that that's not taxation, that's not monies being raised and appropriated through taxes, but could you just clarify some examples of what revenues approved by the legislative body might be?
No, I actually don't. Again, I think that was a catch-all because to the other member before was speaking about sometimes we don't know all what's going to come up in the future. The intention of the bill is that, again, because you're specifying, when you create a fund, you have to specify its purpose, and you would also specify what the funding sources are that when you create the fund. And so I think this is I guess if I were to look at this, and I would use Representative Mangiapudi's statement about net metering. So you may set up some sort of fund where the revenues coming in from net metering might go into a fund that would future fund other net metering projects within the county or town or city. So rather than have it so that it's a self-sustaining fund that allows growth within the community in a green energy environment. That could be the purpose. Again, it's up to the legislative body to decide that. But I think that's the intent of that, is to identify that if there's a revenue source that's directly related to the purpose of the fund, that revenue source could be used for that fund.
Any other questions? Yes.
Thank you, Mr. Chair, and thank you for taking my question. This may be covered in here, but on the wild aspect that a county might have some extra money in a revolving fund, could they donate that to a town's revolving fund for the same purpose of like an ambulance service from the county and the town?
So again, I I didn't hear all of your question. You were a little too far from the mic, so I couldn't hear you. But if I understood your question about ambulance funds or donating money. So again, you could create a fund that would allow for donations. Again, if that was one of your, some citizen wanted to donate money towards an ambulance. Again, my town also has an ambulance fund, and we use the ambulance billing process to keep that fund so we can pay for our next ambulance when we need it. So you could, in theory, do that also. I don't know that many counties that have ambulances or fire trucks, but.
Or we'll give away money.
Any further questions? Oh, Representative Tripp.
Thank you, Mr. Chairman. Thank you for taking it's not a question, it's there appears to be some clericals in the bill. If we go to page 2, line 27, it says, shall not be considered part of the county's general surplus. Should that be city?
Yes, again, I think this was a cut and paste that the
I
OLS did.
agree, I'm
Yeah.
just pointing
Correct.
out there's some clericals.
Correct.
If you go to page 3, line 24, it says the county general funds again.
Right.
So it should be village district, so,
Yeah.
like I said, there's some clericals.
Yeah, I think there was just an error by the OLS in
Point.
correcting it,
I
so
agree.
it would need an amendment to clear that. To be honest with you, it wasn't our intention to scoop in all these other ones, and I'd be completely okay with you removing the city villages and everything else, and just make it about the county, because that was the intention of this whole conversation.
Any other questions? Seeing none, thank you, Representative Lyon.
Thank you, Mr. Chairman. Thank you, committee members, for taking my testimony.
And we have some additional testimony on this bill from NHMA. Catherine.
Good morning once again. For the record, my name is Catherine Heck from the New Hampshire Municipal Association, and thank you for allowing me to speak, Mr. Chairman and committee members. We take no position on this bill, as I did speak to the sponsor, and the goal of this bill, the intent was to allow counties to have the same powers as towns, cities, and village districts. We did want to point out, and I did speak to the representative who sponsored the bill, that currently, cities under RSA 44.1 do have the powers to open and run and establish these revolving funds because they have the same powers as a town. And under RSA 52.1, village districts are allowed to use any provision a town has once they're created to further the purpose for which they're created. So if they're running a fire safety program, they can have it for the fire services, for example, because it's a specific reason. So the law already allows for that, and we are concerned that this actually doesn't clarify. It makes it less clear what the law would be, because village districts could interpret that they could expand their ability to open revolving funds for purposes for which they were not necessarily created. So towns under RSA 3195H, that is the template and standard language that you're seeing throughout this bill. We have asked that the counties review this, or we request that the committees, because counties do not necessarily perform some of these functions. So I'm not sure that the legislation, and again, we don't represent the counties, but would need to address items that counties do not currently perform, or have the capacity or the legal authority to perform. And finally, for consistency's sake, if the committee wishes to leave the language as it is written for cities and village districts, they're giving the commissions the ability to be the custodians of the fund, and typically that's a treasurer's role, to be the custodian, not the governing body, but a treasurer. That needs to be separated to be consistent throughout the law. And finally, there was a question asked by a representative about fees and charges and other income. The purpose of these types of revolving funds is to have a revolving source for self-funding programs, or to offset costs through self-funding as much of a program outside of taxation as possible. So the legislative body, when they create these funds, allows for fees, charges, and any other income it sees fit during the creation of the fund to go in, and recreation is one of the easier examples because if you have a baseball program and you charge $35 so that children can participate, it's so it can continue to grow that program and you're not raising and appropriating those dollars in the future. Any surpluses in those funds can certainly be used only for the purpose for which the fund was created, so they cannot be transferred for other purposes, if that makes sense. So recreation cannot buy a fire truck, if that makes sense. So any surpluses that grow are to sustain the programs for which they were created, and that is the design of the funds, and I believe that's the intent of the sponsors, to allow the county to have the same authority to do so.
Any questions for NHMA? Yes, Representative Tripp.
Thank you, Mr. Chair. Thank you for taking my question. If a revolving fund is created for a purpose and that purpose goes away, what happens to those funds?
So that has to be a vote at the town meeting or by the legislative body to close the fund and repurpose those dollars. And it should be still relatively within the intent for which it was created, but that's a specific warrant article or vote by a legislative body, sir.
Thank you.
Yes, Representative Manchapudi.
Thank you, Mr. Chair. Thank you for taking my question. So if a revolving fund is established, and could it be invested separately to make it a more sustainable fund? Or does it come under other regulations that, it's a...
You mean in additional investments, like to gain interest? Yes, it can be in an interest.
Say, for example.
It can be in an interest-bearing account. However, it has to use all the prudent investor rules. It certainly should never lose any principal. I mean, there's all sorts of rules that go around that. But yes, it can be in an interest-bearing account.
Okay, thank you.
You're welcome.
Yes, Representative Power.
Thank you, Mr. Chair, and thank you for taking my question. So based on your analysis of the bill as written, is it your opinion that perhaps to address the points that you addressed in your testimony, that there should be, it would behoove this committee to look for an amendment to address those points?
Yes, we would like the sponsor who has agreed to consider proposing an amendment that would strike the village district and cities out of it, and I have requested that, again, they have a conversation with the counties to make sure all the language is consistent with county authority and the purpose for which counties can operate, so that the law is consistent throughout. Thank you for your question.
Any further questions for NHMA? Seeing none, any questions from the audience or those that might be interested?
Mr. Chair, the only thing I'll say is I'll be happy to work that amendment, so the committee doesn't have extra work. If you'd like me to, I'll get it drafted and bring it to the committee so you can vote on it.
Thank you.
Thank you very much.
Thank you. Okay, hearing no further testimony on HB 1184, I'm going to close the hearing. And we are going to take a lunch break, and I would ask everyone to be back in their seats by 1:30. How's that sound? 1:30? Eat fast. We'll get out here a little earlier. 1:30? I'm sorry, 12:30. Okay. Good catch. I'm going to take a nap. All right, see you at 12:30.
Representative Majority.
My friend from Litchfield, how can I help you?
I took offense to your reference to people who have high degrees. I don't think that should be held against anyone.
You know, I will say,
Welcome back in session. We're going to hear from Representative Gallagher, who's going to introduce HB 1219.
Hi, thank you. So I'm here to, I'm Eric Gallagher from Merrimack County District 15, that's Concord Ward 6. And I'm here to introduce HB 1219 relative to parking requirements for religious institution affiliated housing development projects. And I seem to remember previously there being something about like if you're on the committee, you can only introduce it, but you can't also testify to it or something? Or
Right.
what's the
way
procedure again?
The way the rule goes, you can introduce it and you can speak to the bill, but you can't, once you're done speaking to the bill, you can't continue to advocate for the bill either from where you are or if you come back to your seat. You can vote on it when it comes time to vote, probably in the next session, but yeah, you can't advocate for the bill. That's your bill.
Okay, so that's after I go back to my seat, so I can speak to it now then?
Right.
All right, so, so this bill is basically to prevent requests for churches to build housing from being denied on the basis of parking. So it's based off of AB 1851 from 2020 in California. I heard about their legislation and thought, hey, this could actually help solve some problems that we're having here in New Hampshire with housing. So you've probably all heard of the term NIMBY for not in my backyard, and some of you have probably also heard of the term YIMBY for yes in my backyard. Phrase associated with this is YIGBY, yes in God's backyard, which I wanted to make that the title of the bill, but OLS wouldn't let me. So basically, one thing that urban development advocates dislike is when there's a church with a really large parking lot and it only gets used for like say once a week if the church only has services once a week. And some churches have agreed, yeah, we might want to turn our parking lot into housing. So they go and try to turn their parking lot into housing, but then they get stymied by local zoning rules. So if you look out the window there, you can see the Sacred Heart Church on Pleasant Street. That used to be a church. It was able to get turned into housing because the church had completely shut down and just wasn't even being used as a church at all. It was sold to someone else and then redeveloped. So none of the usual religious zoning requirements applied anymore. However, there's some other churches exist where the church hasn't closed entirely. It's just got a declining congregation, and they want to continue using their church as a church while also maybe turning their parking lot into housing or some of the rooms within the church into housing. So I'm not quite sure if this is a conflict of interest or not, but my own church, Wesley United Methodist Church, runs this program called Family Promise, where we house homeless people temporarily and want to set up the offices for this program within our church. I don't know if that would apply specifically to this case since it's offices rather than actual housing itself, but just an idea of where I'm coming from. I see this as both a housing issue and a religious freedom issue. Many religions and denominations see it as part of their calling to help our unhoused neighbors, and I believe that we should be making it easier for them to do so rather than putting additional requirements on them. So as for the specific language in the bill, yeah, that's all. Basically, I just asked OLS to adapt AB 1851 for me for the purposes of New Hampshire law. The requirements, it prevents planning boards from requiring, that's where they got all that language from. I'm aware there may be some objections about local control, since it prevents planning boards from being allowed to it prevents planning boards from being allowed to make requirements for things, but I see it as just making an attempt to make local control even more local, moving it from the municipal level to the congregation level. So why focus on parking requirements specifically as opposed to other zoning requirements that might come into play for housing like this? Well, parking, one thing about parking is it contributes to the pervasive car culture that our state has. I don't have a car myself, and it's often just the general assumption that everyone has a car and that and everyone should have a car. That gets reinforced by having parking requirements for things, and it doesn't really do much for those of us who are either too poor to afford a car or object to car ownership based on moral or religious grounds. So I think it would be better to use parking spaces for housing people instead. So that's why I proposed this legislation, and I'll take any questions.
Any questions from the committee? Yes, Representative Majapudi.
Thank you, Mr. Chair. Thank you, Representative Gallagher, for taking my question. I have two questions. One is, would this be transitional housing? You talked about people without homes and, or would it be like a residential co-op where it's people who cannot afford on their own to own a home or a small and live in walkable community kind of thing? So from those two, which kind of housing are you looking at?
I think either would be fine. The legislation doesn't specify one or the other. It just says developers, it applies to housing development projects affiliated with a religious institution. So I think if a religious institution wants to do either of those ones, that it could apply.
A follow-up, Mr.
Yes,
Chair.
go ahead.
Thank you. A few years ago, over a decade ago, Nashua, I was part of the Nashua Interfaith Council, and we had religious organizations, churches, and temples hosting a whole group of people with no homes and transitional, and they were housed temporarily. I mean, they could sleep, but they had to rotate, and finally the group managed to get school that had convent that had open space or the large space, which made it a long-term transitional housing, which is called the Rosemary House, which gave extended period, not like the short-term transitional. That helped significant number of families that had children that could stay in a home and could save, get a job, and move out in 2 years to have their own place. So that kind of gave a good base in, Nashua and area around. So that, from that thought process, I'm asking if it could be, at that time, because we didn't need the new building, it was in the basement of the churches. But if this is in building something in a parking lot, that would be a more permanent, that could help transition. So with that.
Yeah, I think that's a good example of a situation that this legislation could help with.
Any other comments or questions? Yes. Representative Tripp?
Thank you, Mr. Chairman. Thank you for taking my question. I noticed in your bill that you use the phrase religious use parking spaces. Is that a number?
Well, it says the number of religious use parking spaces. So since it's not saying it's not setting like a statewide number that religious use parking spaces always have to be. It's just restricting what criteria local planning boards can set for that number.
Follow-up? I noticed on the, there's also on line 20, it says, the planning board may require one parking space per unit. Is that a minimum or a maximum?
I think it's an exact, as in may require exactly one. I think that's just to handle the case of the legislation potentially preventing planning boards from setting any parking requirements whatsoever. I think instead it's just saying, okay, you can set a requirement, but it can just be this rather than your current full range of requirements that can be set.
Thank you.
Yes, Representative Davis?
Thank you, Mr. Chair. Thank you, Representative Gallagher, for taking my question. It's kind of an ill-formed question, but I'll give it a try. Do you anticipate or do you know of any religious organizations that have created these kinds of housing developments? And have those religious organizations had to set up a separate corporate entity to do so? In other words, could they no longer enjoy their tax-exempt status if they became landlords or developers? And my follow-up question is, can you anticipate any objections by commercial developers who might claim that religious institutions were being given an unfair advantage and a preference that they do not enjoy?
Well, as for the first question, the California legislation that this is based on has only been law for like a year and a few months at this point. So I'm not quite sure what exactly the structuring of organizations to build this housing under the terms of legislation there are using. As for the second one, I mean, as to whether it's privileging religious institutions over commercial ones, I mean, I think so does our Constitution. It provides a freedom of religion, but it doesn't provide for a freedom of commerce. So I think it's okay to be preferencing religious institutions over commercial ones in that context.
Yes, Representative Gilman?
Thank you, Mr. Chair, and thank you, Representative Gallagher, for taking my question. I am guessing at what religious use parking spaces actually is defined as, but I really think the religious institution affiliated housing has some opening spaces. Do you consider that housing for people who attend the church on which the property the church is on?
Or could you rephrase the question?
I just want to know if in your definition of religious institution affiliated housing, if one of the requirements of being renting one of those units is that they are a member of that house of worship.
I don't think they have to. Or so yeah, there's a breakdown between religious use parking spaces and then other parking spaces. So this is about replacing the religious use parking spaces with the other type of parking spaces. So my assumption would be that if the religious use parking spaces can't currently be used as parking for housing, then that this legislation would mean that would remove that requirement and mean that they can be used for housing regardless of whether or not the person in that housing is a member of the institution or not. It would just be general purpose parking rather than specifically religious use.
Thank you. I do. Have you considered the tax implications of this? Because if the housing is on a nonprofit church property, then we're not paying any taxes for the living, housing? Or do they have to divide the lot so that there is the nonprofit church and then the for-profit?
So this legislation is just about the reasons why a planning board can deny permits for a housing project. If a planning board wants to deny a permit for one of these projects based on tax grounds, they can still do that because that's not about parking requirements. It's just saying that it can't be solely due to parking is the only thing it's saying here.
Representative Maggiacuni?
Thank you, Mr. Chair. Thank you, Representative Gallagher, for taking another question. I'm just trying to clarify. Parking spaces for a religious entity is based on the number of members in the congregation or attendance on an average, correct?
I believe so. That sounds correct.
Or the capacity of the building that can hold 200, whatever, and then you have to offer. So this legislation is only addressing to use the parking lot, so don't deny construction of housing on the parking lot based on the membership congregation. And you also alluded to the fact that dwindling congregation members, so the church might have a capacity of 250, but currently only has 100 members.
Yeah.
Is that your intention?
Yeah, I believe that this addresses that.
Okay, thank you.
Yes, Representative Maggiore.
Thank you, Mr. Chair. Thank you, Representative, for taking my question. Does this bill, or do you contemplate with this bill that we are only talking about one lot, or are you talking about all of the property that is owned, contiguous or not, by the religious institution? Thank you.
So to be honest, I'm not really too familiar with how the development process works. My assumption would be that it would just be done one unit at a time, but I guess there could be potential for multi-unit projects in here as well. I'm not sure if you'd like there to be language clarifying that, I'd be open to that.
Yes, Representative Romm.
Thank you, Mr. Chairman, and thank you, Representative Gallagher, for taking my question. Are you aware of any religious institutions in New Hampshire that are currently exploring having housing on their property? And if so, if this has been an impediment to them moving forward on that housing project?
I mean, my own, but I don't really know much about, yeah, I haven't really consulted much with people from other congregations, though.
Any other questions for Representative Gallagher? Seeing none, thank you. And now we have some commentary from the NHMA. Mr. Graves. And Nash, feel free to wipe the mic with the Clorox if you want.
Nate Grays for the New Hampshire Municipal Association. We object to this bill. There are a couple items that I would like to point out. Our main objection is this is a statewide zoning mandate, which we oppose generally. We prefer that, and current law provides that most local land use decisions are made at the local level, and that's what we advocate for. There are a couple technical questions I have about the bill, and I don't have answers to them. As Representative Tripp pointed out earlier, there's no definition of religious use parking spaces, and I'd also note that there's no definition of religious institution affiliated housing development project, and that leaves it a bit vague about how this would apply and specifically how this would act as a law. I understand the sponsor's intent is to allow religious organizations with large parking lots that are seeing declining membership to convert a portion of those parking lots to housing, but I don't think that's necessarily captured by the language of this bill. I would also echo, or I guess answer in the affirmative, Representative Maggiori's question that the language here used is vague, so it's not clear that we're specifically talking about parking lots in all cases. It could be the case that a religious institution, whatever that means, decides to develop some housing on another portion of their property, and that under this provision appears to relate to how many parking spaces they need, and it's just not clear how that's going to interact. And the last thing I wanted to point out is that over in the Judiciary Committee, I just learned as this committee was meeting earlier today, there was a bipartisan recommendation of ought to pass on HB 1021, which, for the record, we opposed. Appears we've lost that. But that would modify RSA 674:75, or I guess add a new provision there that says no zoning ordinance or site plan review regulation shall prohibit, regulate, or restrict the use of land or structures for religious purposes, and it goes on from there. But that may have the same effect as this bill. I haven't analyzed the two together, but I wanted to point that out to the committee since I know it's the policy of the General Court to try to coordinate legislation where possible. I'm happy to take questions.
Sure.
Yeah, if it turns out that the other bill is broader and does in fact do the same thing as I'm trying to do here, then I'd be okay with withdrawing this one and just letting the other one do its thing.
Any other commentary or questions?
Thank you.
Seeing none, thanks. Natch Grays. Okay, looks like we're out of speakers. So I'm going to close the hearing on HB 1219. Okay, we're close to being done, and you'll know why in a second. Next on our calendar is here we go, HB 1223, relative to meeting attendance requirements for elected members of the Budget Committee and School Board. I'm going to open the opportunity for questions and comments, but I see we're starting to have deteriorating weather, and I want to cut this short and recess this. So does anybody have any comments about HB 1223? With the understanding that on Monday when we convene, I'll end the recess and reopen it for more comments. Yes, Representative Power?
Thank you, Mr. Chair. I have a question. So will this bill be introduced on Monday or not?
it could be if there are more people here to carry that function out. If not, one of us can introduce the bill. Representative Brown, you had a comment?
Well, I just wanted to say that I think that a lot of municipalities already have attendance requirements for budget committee and school board. And I was just wondering why towns were omitted from this and village districts. That was just mine. It just
Yeah,
seems to be.
I think you're right. I know in my town, if you don't show up for a certain number of meetings in a row, you're kicked off the committee. I don't know about the school board, but they may have their own special rules. Any other further comments before we end the session? All right, yes, Representative Tripp.
So this would be the way to remove an elected official? Well, I'm more concerned with the elected, not the appointed.
Yes, I think that removing elected officials is a very delicate process. And I would think that this would have to have a little more research done on it to see if what we're saying here can actually be done. With regard to removing an elected member of the school board or a budget committee. Yes. She said it's discriminatory against people who have an illness. Yes, Representative Wrong?
Yeah, another question I would have for Monday is that it says shall be considered to have created a vacancy. So I guess that is removal from office. If it's creating a vacancy, or is it adding another person? Yeah, so it is, just following up on what Representative Tripp said, I would consider that very seriously if we're taking away a position that the people have elected, because there could have been an illness or surgery, or there could be a lot of reasons. Thank you.
Right. Further questions, comments? All right, seeing none, going to recess HB 1223, and we'll take that up Monday morning in addition to the other bills. Those are all bills. They're not executive sessions on Monday. So thank you all, and drive carefully. It's starting to...
What is the status of the weather?
It's starting to rain, and we're supposed to get freezing rain this afternoon and snow tonight and tomorrow, depending on where you are in the state. Getting that way. So you're going to check with her to see if we're